Hi, my name is Kristen Price and I'm a law clerk at Edwards Law. Today I'm going to talk to you about medical incapacity and provide a basic overview of the obligations imposed on employers who need to terminate for medical reasons. Medical incapacity is where a long-term illness or injury relating to both physical and mental health renders an employee incapable of the proper ongoing performance of the job they were hired to do. An employee's ongoing absence can place significant strain on a business's operations. However, medical incapacity is a tricky area of the law. It can be a very sensitive issue for an employer to deal with, especially where it is unclear as to when an employee will return to work. It is well-established law that an employer is not bound to hold a job open for an indefinite period, where the employee is sick or prevented from carrying out their duties. There will always be a stage at which the employer can fairly cry halt. The emphasis is on fairly, and what is fair will depend on the particular facts of each case. Accordingly, as with any dismissal, the focus is on whether the decision to dismiss is one that a fair and reasonable employer could have made at that time in all the circumstances. A dismissal is justified where it can be shown that the decision to terminate was both substantially justified and was carried out in a procedurally fair manner. In 2017, the Employment Court set out 7 principles that should be considered before terminating an employee for medical incapacity. This framework is a good starting point and reflects the need to balance the interests of both parties. First, the employer must give the employee a reasonable time to recover. However, what is reasonable will depend on the nature of the injury, particularly in the case of mental health, where obtaining a firm medical prognosis can be difficult. 2, the employer must carry out a fair and reasonable inquiry. This involves engaging with the employee, as well as seeking and considering all relevant medical information. The employer should also look at an appropriate return to work plan for the employee. The aim is for the employer to have all relevant information before it that is necessary to decide whether ongoing employment is viable. The decision should balance fairness to the employee against the practical requirements of the business. Dismissing before obtaining medical advice or without an opportunity to do so is likely to be deemed premature and unjustifiable. The third principle looks at obligations of good faith, which requires both parties to actively engage in the consultation process. This means an employee should be notified of the possibility of dismissal and given an opportunity to provide input or comment at all key stages of the process. 4, consideration should also be given to certain factors that are likely to inform the employer's assessment of what is reasonable in the particular circumstances. This includes A, the terms of the employee's employment agreement and any relevant company policies. B, the nature of the employee's position, such as if they hold a key role. And C, the length of the time that they have been with the company. These relevant factors should all be assessed before going down the path of dismissal for medical incapacity. The 5th principle states that if the actions of the employer have caused the employee's condition, then the employer may have an ongoing responsibility or enhanced obligations in dealing with this employee. For example, they should take reasonable steps to rehabilitate the employee before turning to the option of dismissal. Principle 6. For completeness, even in a large organisation, an employer is not obliged to keep a role open indefinitely. Although they may be more equipped to absorb the impact of one less worker, a large employer may still dismiss after a reasonable period of time before commencing a process. This is usually after a few months. And Principle 7, the employment relationship is a two-way street. If there is a lack of positive engagement from an absent employee, this could diminish any later complaint they may bring. Remember, both parties are going through this process together, and contemplating termination for medical incapacity is the last position an employer wants to be in. We also suggest that an employer considers whether it will be able to provide an employee with suitable alternative duties. Employers should look at what else is available for the employee, such as lighter duties or administrative tasks. As you can see, medical incapacity can be a complex and contentious issue, particularly as each scenario is so fact-specific. If you find yourself in this situation, whether as an employer or employee, we strongly recommend that you get in touch with us for guidance in this area.